Good morning, everyone. Welcome to our webinar today. Thank you for joining us. 45 minutes in which we hope to prove that the best way to beat away the January blues is 45 minutes of charity law and regulation. So the webinar today, we're thinking that the premise of it is that the start of a year is a good time to take a step back, reflect, look at legal regulatory developments and trends for the sector from 2021, and also what lies ahead in 2022. I'm joined today by my colleagues Carla Whalen, a specialist in people matters for charity, ranging from employment law through to data protection, and Rachel McCarsman, who specialises in governance, commercial and operational matters for charities. I should note that the session today is being recorded, although not the Q&A session at the end. I'd encourage everyone to please do ask questions. You can ask your questions in the chat box. We'll try and pick up some as we go through, but there's quite a lot of material, so we'll probably pick up more at the end of the webinar today. Okay, so starting by setting the scene for all of this, clearly it goes out saying the pandemic still forms the backdrop, the context. It's having huge impacts on aspects of society, including the charity sector, and its implications are still very much playing out and are not yet fully understood. Something that's often commented on by way of example is the huge increase in inequality that the pandemic has led to. Only in the last few days, Oxfam put out its annual inequality report, which it had reported that the wealth of the world's 10 richest men doubled during the pandemic, but the incomes of 99% of humanity were worse off because of it. I hope that's not too depressing a thought at the start of the session. And this context is, of course, putting particular pressures on charities. There's been huge increases in demand, particularly for some charities as a result of the pandemic, reduced income for lots of charities, and significant challenges trying to raise funds. The Charity Commission carried out some research in autumn 2021, and it identified that 60% of the charities it spoke to had income that had fallen, and nearly 60% have been forced to cancel events or planned works. So clearly a huge impact across the sector. Also, sadly, been quite major redundancy programs, certainly at some charities, which has caused issues. That said, in many ways, it's quite difficult to generalize the impact of the pandemic on the charity sector as a whole. It's clearly been devastating for some charities, particularly those dependent on particular kinds of income, charity shops, events, and the like. But actually less so for others, and certainly our experience across our practice is that a surprising number of charities have fared surprisingly well. Some charities, for example, that have a large endowment that they spend to make grants actually have found the value of their endowment increasing. And many charities did manage to get through 2021 in slightly better shape than some had feared. And the numbers that have closed is relatively small, although clearly there have been lots of challenges for all. Looking ahead into 2022, clearly still like to be quite an uphill struggle for many charities, with continued uncertainty of all kinds. And this image on the slides intended to be vaguely positive of a time when we can hopefully start moving forward again, but certainly with some bumps in the road, and it won't be straightforward. The ending of government support, which actually did help charities a lot through the pandemic, is a financial challenge. Some evidence also being reported by NCVO this week and others of falling donations, which is a big challenge for some. Also a concern that some charities may be running on empty, running on fumes, as they've spent down reserves during the pandemic period and now need to quickly rebuild and recover, and questions about how easy it will be to do that in this context. And the Commission research I referred to found that over half of respondents anticipated some level of threat to the financial viability of their organisation during the year, but only 1%, fortunately, foresee that threat as being critical to the survival of the charity. Other challenges into 2022, inflation, potentially quite a big one, reported today that inflation has now reached a three-decade high of over 5%, which can put pressure on a sector that's already struggling because of all the other issues I've outlined. And linked to that, there's likely to be rising demand again, as pressures on household incomes, partly because of inflation and other reasons, play through. So it's still as I say, hopefully the sector is positively moving forward from recovering from the worst of the pandemics, but it's far from a straightforward period looking ahead. So that's the kind of bigger picture setting the scene. In terms of some trends and themes, issues that are a little bit more focused on charities specifically, these are a few that we wanted to pick up on, partly based on what clients are talking to us about. One continuing trend is clearly culture wars and polarization become a big issue for the charity sector that's likely to continue. In 2021, there were high-profile complaints from Tory MPs about Barnardo's after it shared tips on discussing race discrimination with children, and also concerns raised about the Runnymede Trust, which led to quite a lot of media coverage. It's worth noting that in both instances, the Charity Commission looked into the issues and concluded that the trustees had acted properly, but doesn't of course mean that things aren't highly challenging for the organisations having to deal with that. And some charities that have been in the limelight for these reasons during the year, RNLI, National Trust, have stood firm. In the National Trust case, seeing off some challenges to its strategic direction. In relation to RNLI, actually managed to significantly increase its income in the context of the concerns that were raised about it. And NCVO, in its Road Ahead report published in the last day or so, point out that rightly in my view, that the public's opinion on many cultural issues is a lot more nuanced than the political and media narrative suggests. But this put charities in a challenging position where you've got no choice but to, where you have to stand strong, but also work out what's worth putting your head above the parapet for and what might not be. And it can be very unpleasant being caught in the crossfire of these kind of issues, even if you know you're doing the right thing and it furthers your charitable purpose. A theme that seems set to continue. The uncertain political context, perhaps a slightly new one. I mean, as we speak, the government is in one sense both strong with a large majority, but also weak with a prime minister that may not be in office for much longer. I mean, perhaps if I check my phone, perhaps he isn't, I don't know. But it does create some uncertainty, and that may be unhelpful. There's no dedicated charity minister and no publication date yet for the government's levelling up white paper, which is likely to be quite relevant to the charity sector and something the charity sector might wish to be involved in. So there's a bit of uncertainty there. Turning to increases in charity disputes. This is a trend that we're noticing in our practice, an increase in disputes among trustees and within organisations, often highly contentious and anecdotally perhaps increasing sometimes in ferocity, which is a trend that the Charity Commission has picked up on too. Perhaps this partly is a result of wider trends and pressures in society as a result of the pandemic, with a more fractious society, also challenges associated with communicating in this sort of way electronically and rather than having so many face-to-face discussions. But it's something perhaps worth focusing on within charities, taking steps to avoid these sort of issues arising, nipping issues in the bud earlier, focusing still on the importance of good governance disciplines, up-to-date policies and procedures, and also managing people issues as and when they arise, taking the time to step back, review how the board is performing, which can be really challenging when there are all these other issues arise. But the difficulty is that when disputes do arise, they can really throw charities off track, often in quite an unpleasant way. Next theme, impact of Brexit, which I'll just mention briefly. Don't want to say too much about Brexit, but I guess one thought we do have that in some sense, the pandemic might have masked some of the implications of Brexit as people are have reduced their travel to Europe in particular, and fewer people are coming into work from overseas. Again, it's one to watch. And on that, I'll hand over to Carla, who'll talk about flexible and hybrid working.
Thanks, Chris, and thanks everyone for joining us today. I'm just going to say a few brief words. I mean, I think everybody knows that there's been a real growth in flexible working, home working, other hybrid patterns of working over the pandemic, and that just continues, and it has been quite a big shift. For some charities, bringing it back is the issue now that people say, well, I've been working from home for 2 years and it's been fine, so I want to continue doing that. We've heard murmurs for years, really, of plans at government level to change the law so that flexible working will become the default. Some might remember this was included in the Queen's speech in 2019, and that was expected as part of a new employment bill. Fast forward to 2021, the employment bill's kind of silently been shelved. There was no mention of it in the 2021 Queen's speech. Talk of flexible working changes did continue, though, outside of that. There was a consultation which ran from September to December in 2021, various reforms proposed, including extending the right to request flexible working to day one for all workers rather than the 26-week period that currently applies. Interestingly, though, no mention of making it the automatic or default right. So I suppose, where does that leave us going into 2022? I mean, personally, I think this is a good example, really, of life leaving the law behind to some extent. I mean, in practice, so many employers are now offering flexible working of one sort or another and being very open to considering different patterns of working and work arrangements. But it can really be an issue for charities in terms of recruitment and retention of good staff if you don't offer this. Now, obviously, not all roles and not all organisations can offer flexible working. But if you do have a role where all of your competitors and other charities are offering it, it might be that you're struggling to keep or attract the right staff. So, you know, in a way, more flexible patterns of working is becoming the default through practice, if not through law. Just a final point, many charities will already know, because they've been dealing with it for the last year, that flexible working in the longer term in particular brings some challenges, legal considerations, including issues around employee monitoring that can bring in data protection and privacy issues, as well as kind of more human resources, people kind of issues and questions about the longer term impact of having a disparate workforce, impact on team, colleague relations, management of staff, supervision, development of more junior members of staff in particular. It can also create challenges for charities, or some charities, in terms of office buildings. If your charity owns or leases an office building that's no longer required, or you've got a reduced requirement, then obviously you've got to balance the need to use your charity resources effectively, while also making sure that there's still reasonable working conditions for staff when they do come into the office. So I think no doubt we'll continue to see flexible working and related issues being a significant sort of HR people issue for many charities as we go through 2022.
Then in terms of fundraising, the main trend has quite predictably been a move to more virtual fundraising, and it looks like that's here to stay for now. The fundraising regulator published its annual complaints report, and that said that there were less complaints about fundraising overall in the last few years, but complaints about online fundraising had increased by more than 250%. So it sounds like a big number, but really it's more of a reflection of how that landscape is changing. That report has a number of recommendations, which if you do a lot of public fundraising is probably a good thing to have a read through. The most interesting one I thought was to be aware that some charitable causes may attract more hostile attention and scrutiny than others. So that's just something to keep in mind when you're coming up with your fundraising strategy. There's also been lots of guidance about fundraising safely during COVID, and that's still being updated as and when things change. And next year, the fundraising regulator will be publishing a new 5-year strategic plan. They're going to be reviewing the code of fundraising practice and also reviewing some of their guidance. So we can expect some changes there. So next, we thought we'd talk to you for 5 minutes or so about some trends that we've seen in the Charity Commission and where those might be heading. So the first thing to talk about is the leadership. And I'm sure lots of you will be aware of this already, that the leadership's currently a bit up in the air. So Baroness Stowell completed her term as chair in February 2021. And there was a long process of recruiting a new chair, which was Martin Thomas. But then in December, he had to withdraw because of inappropriate behaviour that came out while he'd been chair of a charity. So quite an embarrassing situation overall, and it's likely to be a number of months before they find a replacement. So we'll have to see where we end up with the chair. But if we look back to kind of Baroness Stowell's term, that was really characterised with some quite consistent messaging. So she felt that the biggest challenge facing the sector was falling public trust and confidence, and she wanted to rebuild trust in charities. So her focus really was about demanding higher standards from charities and trustees. And the Commission seemed to have a focus more on its regulatory role rather than its advice and guidance role. And I think it's fair to say that overall that approach, and in particular the way of expressing it sometimes, wasn't always popular in the sector. So it'll be interesting to see if that changes with the new chair, and also whether that changes after the Kids Company case, where the judge criticised another public body for trying to hold charity trustees to a higher standard. And that case kind of indicates that that higher standard approach maybe isn't really backed up by the law. Generally this year, it seems the Commission's been overall supportive of charities during the pandemic. So hopefully this time next year, we'll be able to talk to you a bit more about the new chair and what their approach might look like. The Commission's published its priorities for the coming year, and that's in the context of them recently getting some more funding in the autumn 2021 budget after quite a long period of austerity. So that's kind of an indication of what they might be spending some of that funding on. There's a big focus on improving efficiency in their services and automating more of their services. And we could see the work starting on that in 2021. Slightly ironically, it caused lots of delays because of the change of systems, but hopefully we'll see the benefits of that next year. Another big focus is about engaging more directly with trustees. So we can expect to see some more trustee-focused campaigns, maybe some more guidance specifically for trustees. And then there's this continuing theme of being more robust in regulating charities. And the focus here in these priorities is about being more proactive in uncovering wrongdoing. So they talk about having a more sophisticated approach to intelligence gathering and data analysis. And we have seen the Commission approaching charities more proactively in this way in recent years. So even where there's no reason for them to have a particular concern, just kind of checking in to see if charities are compliant, for example, if they work in a high-risk area. So it looks like that trend is set to continue. And then within that regulatory work, looking at what the Commission's key areas of concern might be. If we look at their compliance cases from 2021, there was a real focus on trustee decision making. I'm not going to go into the details of that today, but there is an article on our website where we analyse some of those key themes and some learning points from those cases. So if you want to read some more, it's worth having a look there. But I did want to just talk about one case that stood out to me the most as a situation that lots of charities could potentially find themselves in. So what happened was the CEO of the charity submitted a serious incident report about something that had happened overseas. And the Charity Commission looked at the information, presumably asked for more things like minutes, and identified that actually there was a bigger regulatory issue here, which is that staff were reporting to trustees at quarterly meetings, but actually the trustees were too trusting of the staff and weren't robust enough in questioning them. And the Commission felt that that had resulted in the charity being exposed to risk because, for example, internal policies and procedures weren't being complied with, or important information was being withheld from the trustees. And they concluded in this case that there was misconduct and or mismanagement by the trustees. So I'm sure there probably are people here who are thinking that's a little bit close to home because it's, not a hugely uncommon issue for trustees not to be as engaged as maybe they could be. So that case is really just a useful reminder to make sure that trustees really are questioning, scrutinising, and also making sure that that's all minuted so that you've got a record as well. And then the last thing that gives us an indication of the Commission's kind of regulatory concerns are their alerts that they put out. So those are the news flashes they send out about key issues. Now, those vary from year to year. And in the previous few years, there's been a big focus on fraud. In 2021, there was only one alert, and that was about managing safeguarding risks when working internationally. And the Commission also did 2 webinars in September about safeguarding and financial risks when working internationally. So from that, we can see that potentially that's something that's becoming top of the agenda again. And then finally, just in terms of new guidance, Chris and Carla will speak to you about changes to the safeguarding and responsible investment guidance, so I won't talk about those. But I did just want to mention the new 5-minute guides that the Commission published, which are on key areas of governance. And they're designed to be quick and easy to understand, so they're pretty useful for things like inductions for new trustees. All right, I'll pass on to Chris now, who is going to talk to you about the Charities Bill.
Thanks, Rachel. And just pick up on that in relation to the, excuse me, the Charity Commission. I think we're experiencing in our day-to-day work helping clients with various matters in relation to the Commission, much closer scrutiny of all sorts from the Commission and the requirements for greater detail for things that might require less in the past, whether that's a charity application or making an application for a change to the objects of the charity. It tends to be a more complex process where the Commission both wants to know more and will ask more questions about it. Although we also experience quite a lot of inconsistency with the Commission, that they can sometimes be very efficient and fast, and we obviously try to do our best to ensure that that's the experience our clients have through our understanding of the Commission, but they can also get bogged down sometimes in quite small issues, which obviously we seek to avoid. In terms of, so just before talking about that, so I've just seen a comment in the chat box from a colleague, from Carla, and I'll pass this on. So somebody raised their hand. We're not using that function today. There's 120 people on the call. If you do have comments, thoughts, questions, would you kindly type them into the chat box, and we'll pick them up that way. So turning to the Charities Bill, it's really getting exciting now. This is a piece of legislation that has just passed its third reading in the Lords. It implements some recommendations by the Law Commission that were made over a period of years, and the main theme is its useful practical changes and simplification, but it's really quite technical legislation designed to make the law more straightforward for charities and trustees, and plenty for us to get excited about as lawyers, but for most charities day to day, it shouldn't have too significant an impact. That said, there are some areas where it might be useful for people to be aware of in general terms, so that as things develop, you may be able to make use of new powers and opportunities under this legislation. In summary, some of the changes include making it easier for charities that are unincorporated in particular to make changes to their governing document, the greater power to apply the proceeds of failed fundraising appeals for new purposes without having to go to the Charity Commission for consent. And of course, those sorts of problems can be avoided by framing appeals in a way that gives some wriggle room if too much money is raised or too little. A significant increase potentially in the thresholds for making ex gratia payments without the consent of the Charity Commission, and ex gratia payments in this context means payments that are made by charity trustees where they feel they have a moral obligation to do so, but no legal obligation. Most often come up in the context of legacies that charity receives, where it may be as a result of the legacy to the charity, some injustice as the charity perceives it is done to a family member, and the charity feels that something should be distributed to them. Simplification of the framework for buying, selling, leasing and mortgaging land, including a much wider range of people who can give advice to trustees on property disposals, going beyond qualified surveyors, something we'll be picking up on, and our specialist property colleagues will provide more information about once the legislation is passed. Some greater flexibility on permanent endowment, spending it, making changes to it. So permanent endowment being property where you're obliged to retain the capital and can only spend the income, and some provisions that may help facilitate charity mergers and avoid the need to have to retain potentially a shell charity on the register of charities. In terms of what you should be doing now, potentially not a huge amount. It's worth noting one of the other changes is the Charity Commission having additional tests for approvals to changes to the objects of charitable companies and charitable incorporated organizations. And so if you have that legal form, it might be worth thinking about going ahead of the legislation and making some changes to your purposes. Now it's possible it will become slightly more difficult. Also, some new Charity Commission powers requiring charities to change or stop using inappropriate names, and to ratify the appointment and election of charity trustees where there's some uncertainty concerning the validity of their election or appointment, which is an issue that often comes up in practice and in our experience. There are questions, given its resource, about how easy it will be to get the Commission to exercise some of these new powers, even though they seem to be useful on the face of it. So legislation has nearly completed the process of going through Parliament, but it will be some time until, even once it's enacted, until it's actually implemented, and the Charity Commission will need to produce some guidance that accompanies it. So we'll keep people up to date in our charity updates and otherwise on this. But if there is anything that anyone immediately thinks might be of interest or relevance to their charity, do get in touch.
To say, Chris, actually, we just had one question on one of the topics that you touched on there, ex gratia payments, and the specific question about whether that guidance applies to settlement agreements where the charity might be exiting an employee, particularly where it's a senior employee.
So no, so that's a, oh, sorry, good. Yeah. No, thank you, Carla. I mean, and that was the distinction I was making. So I explained that ex gratia payments in the context of this is not actually the way in which most people use ex gratia payments. They're in the way that Carla described in the context of settlement agreements. An ex gratia payment for the purpose of the legislation, as I say, is these limited payments where you're just making them because of a moral obligation, as I say, most commonly in the context of will disputes. The term ex gratia payment, which I think this comment is talking to, often refers to payments that are made perhaps under settlement agreements for leaving members of staff. The term ex gratia payment there is used in a slightly different way, and the basis on which charities often justify such payments are not because of only a moral obligation, which is the type of ex gratia payment that the Charities Bill is talking about, but actually because it's been identified, often with professional advice, that it's in the interests of achieving the purposes of the charities. It's in the charity's interests to make the payment. For example, if there's been a dispute, it may be there's advice saying, well, if you make this payment under a settlement agreement, you will avoid the risk of a particular exiting employee bringing any legal claims against you, which could be at the amount or higher than that amount. So the answer is no, it doesn't apply to that type of payment, although you still have to take great care in relation to it, because when making ex gratia payments under settlement agreements, for example, charities need to be able to justify both making the payment at all and the nature of that payment. And there's been lots, and Colin may pick up on it later, said in recent times about so-called sort of gagging clauses and employees being silenced when they leave under the terms of settlement agreement. But I'll say no more on that for now, and perhaps move on to the next topic. But thank you, that was a very useful question, I think. So, responsible investment. During the course of 2021, there's been a real increase in sort of so-called ESG investing, thinking about responsible investments. It's really perhaps the year where the sector particularly took off. And many charities have been considering both their own investments and also the investments of others. We've been working with several charities doing highly innovative pieces of work, seeking to persuade others, such as pension funds and individuals who have pensions, to try and invest those funds in a way that's more responsible, perhaps, than historically. And during the year 2021, the Charity Commission consulted on some new investment guidance. And the reason for that guidance was to try and make it clearer that trustees do have the power to adopt responsible investment strategies, even if it might harm a financial return if it's in the charity's best interests. Of course, as an aside, one of the positives in 2021 is that often responsible investment can also be justified on purely financial terms, because that sector of the market has performed quite well in financial terms too. And the Charity Commission suggested quite a wide range of factors that trustees could take into account, including reputational risks and potential impacts on donations, that could be relevant factors that enable trustees to justify investing perhaps in endowment or reserves in a more responsible manner. And the guidance included some, there's a little bit of, this is where the potential catch comes, that the guidance included interpretation of the leading case in this area, which is known as the Bishop of Oxford case, which is from 1992. And in that case, the court limited considerably the circumstances in which trustees could take into account anything other than the need to maximize financial return when investing the assets of the charity. The court identified that the circumstances in which trustees can make financially disadvantageous investment decisions for ethical reasons are extremely limited. And there are some long established sort of exceptions where this is clearly can be justified. So, for example, a cancer charity may exclude tobacco companies from its investment. Clearly, such investments will be contrary to its own charitable purpose, and it's relatively straightforward to justify that sort of screening, relatively limited screening and exclusion. But things get more complicated if there isn't a particular connection between the investment decisions and the purposes of the charity. So you may have a healthcare charity that is where the trustee didn't want to invest in companies that might contribute towards climate change. Of course, you could argue there's a big connection between climate change and healthcare in one sense, but on another, there's not such a direct connection between the investment decision and the purpose of the charity. And this is where there was some uncertainty and trustees being concerned about whether they could be criticised for making decisions other than for best financial return. So in light of the uncertainty and the doubts and uncertainties about whether the Charity Commission's revised interpretation of the law, apparent revised interpretation of the law, is correct, a case was brought by two charity trustees, the case of Butler Sloss and the Charity Commission, which involved two trustees of environmental charities who wanted policies that excluded investments not in line with the Paris Climate Change Agreement, granted leave to ask the High Court to declare the nature and scope of their power of investment as charity trustees, one, and two, how they might properly discharge those powers in circumstances where particular investments or investment policies might be seen to be inconsistent or in direct conflict with their charitable objects. Kind of quite interesting and complex area. The hope is that as that case proceeds during the course of 2022, is that the court will provide much greater clarification and give the trustees of charities much more scope to carry out responsible investment in line with their values, which will then enable the Charity Commission to finalise, hopefully empowering guidance for trustees in this area. In the meantime, there is already quite a lot the charities are doing, so you shouldn't feel too restricted at the moment, and people do want to discuss these issues. We talk to us or investment advisors. But as I say, greater clarity expected at some point during the year. And of course, also important to note, as I mentioned, that increasingly responsible investments can be justified on financial terms as well as because of the moral responsibility. I suppose I should say, of course, we're not investment advisors, can possibly suggest where anyone should be putting their funds, but the courts may have some thoughts for you later on in the year.
Great, thanks, Chris. So I'm going to sort of canter through a few updates, firstly on data protection, and then I'll turn to people-related updates, including HR and employment law. So I think probably the most significant development really recently in data protection has been the appointment of a new commissioner, information commissioner in the UK. Elizabeth Denham left office after a brief extension of her term, and John Edward took over as the Information Commissioner earlier this month. He was previously Privacy Commissioner in New Zealand. His background is in law. He was a solicitor and a barrister. Make of that what you will. What do we know about him? Probably he is arguably most famous for tweeting something after the 2019 Christchurch mosque massacre, where he described Facebook as morally bankrupt, pathological liars who enable genocide. That tweet is now deleted, so you won't be able to look at it with your own eyes now, but it was it caused a bit of a stir, and I mean, could perhaps suggest he takes not scared of taking a slightly stronger stance, or at least using stronger words than Elizabeth Denham, who was sometimes seen as being a little bit weak when it kind of came down to the wire. I suppose in a more serious way, in New Zealand, he oversaw the implementation of their Privacy Act 2020, and he also got an adequacy decision from the European Commission for New Zealand. So I think looking at the UK landscape for data protection regulation, all those post-Brexit agreements, plus proposed changes to the regulatory landscape in the UK following Brexit, you can sort of see why he may have been an attractive candidate for the UK Commissioner at this time. And that sort of takes us on to those proposed data protection reforms. So for those people who just thought, well, we only just got to grips with the GDPR and the Data Protection Act 2018, there was quite a lengthy document published by DCMS, the Department of Culture, Media and Sport, who it seems are also the Department of Data Protection, last year. I couldn't possibly summarise it all here, and some of it probably wouldn't be that applicable to most charities anyway. There's a lot in it about innovation and encouraging business. Some changes that will affect everybody are quite administrative in nature, but if anyone on the webinar today has particular sort of data protection responsibilities within their charity, then the idea that it will be sort of out with the obligation to appoint a data protection officer, out with data protection impact assessments, out with the obligation to keep records of processing activity, is quite a big shift in terms of the kind of administrative work that goes on behind the scenes in data protection. The idea is to replace that with something that the government describes as a risk-based accountability framework based on bespoke privacy management programs tailored to an organization's individual data processing operations. How that actually will differ in practice from what we have right now remains to be seen. But I think the aim overall is to reduce the kind of data protection compliance burden on smaller and medium-sized organizations, which I know lots of people on the call today will probably agree is relatively significant. Other things in those proposals that were pretty interesting from the point of view of the issues that we advise charities on regularly, relaxing consent requirements when it comes to cookies. Increasingly, people are using cookies, not just in the way that we used to kind of monitor, use the kind of Google Stats cookies to monitor who's visiting your website and how they're using it, but also things like, understanding who is opening emails, who's reading them, who's scrolling to the bottom of them. They all require cookies or similar technologies, which are supposed to have GDPR standard opt-in consent. That kind of links into a bigger issue for the regulator, for the ICO, about enforcing cookie consent rules against a kind of global ad tech business that really does not want to be reined in. Extending what's called the soft opt-in for charities is one proposal that I think got quite a bit of attention in the sector press, because it could have a real impact for charities. This would basically mean that charities would not have to get prior opt-in consent to send those kind of marketing emails to people if you already had a relationship with them. So you could promote your organisation and what you're up to people who had previously subscribed or donated. So the ICO has called for clarification almost immediately on whether this would actually apply to fundraising, because I think they're concerned that a sort of green card to send people fundraising materials could have a significant impact on privacy. So kind of watch this space, but it's sort of at least good to see that that's been recognised as an issue for the not-for-profit and political parties sector in particular. And that consultation on those proposed changes closed in November there. So we will need to keep an eye on kind of how those plans develop. And obviously that might interact with the appointment of the new commissioner, as I'm sure he may have input into that. I think, frankly, it's unlikely we're going to see changes to data protection legislation, at least until the end of this year, at the earliest. I'm not actually going to focus particularly on penalty fines or particular data protection court cases from the last year. Really, the message is just the issues that required the ICO or even the courts to take action, including against some charities, really didn't change significantly from previous years. It's compliance with PECA, privacy and electronic communications rules, so things like telephone calls, email marketing, and the requirement for consent. There's also in that proposal for new data protection reforms, a proposal to increase the maximum fine for those PECA breaches, which currently stands at 500k, up to match the fines for GDPR breaches. So in theory, sending emails of a marketing type without appropriate consent could carry the maximum £17.5 million or 4% of global turnover fine. Doesn't seem likely unless you were doing something really awful with those emails, but could be quite a significant change. The other one is security breaches, age-old story. Largest percentage of increase in security breaches reported were in hardware and software misconfiguration, up 700% apparently, and also ransomware attacks. We know that cybersecurity was a big issue during the pandemic, particularly with people working from home, up 564%. So really big increases on those. Final point to make on this slide, the ICO has launched a consultation on its own regulatory action policy, which is in draft form. That's open until the end of March, 24th of March. So if anyone does want to have their say on how the ICO enforces data protection rights and data protection law, you can go on pitch in on that consultation on their website. So moving on to developments in relating to people, I mentioned earlier that the kind of employment bill that was expected seems to have kind of been shelved, and to be honest, we're not really expecting any significant changes to employment legislation in 2022. The things that I'm going to focus on just for a few minutes are recent consultations and select committee reports on equality laws and prevention of discrimination in the workplace. So we hear continued calls for ethnicity pay gap reporting, so sort of similar way to the gender pay gap reporting obligations. And the latest from the government is that they're going to respond to the consultation on that in due course, which I think suggests it's not a priority. In mid-December, just there, the government launched a consultation on disability workforce reporting, again, kind of mandatory reporting on the proportion of employees in a workforce who identify as disabled. Again, it's likely that will only apply to larger employees, sort of 250 plus employee threshold. But the consultation closes on that on the 25th of March, so we can expect a response to be published in around the middle of the year. In July last year, the Women and Equalities Committee did an inquiry into discrimination and workplace practices around the menopause. And this is also an issue that we've seen coming up in some tribunal cases as well. In those cases, often the question being whether symptoms of the menopause can constitute a disability for Equality Act purposes. The Women and Equalities Committee report was to consider whether further legislation was required to make employers have a workplace policy to protect people going through the menopause and to address gender equality issues. So I do think that is something we will hear more about. The inquiry closed in September, so let's just watch that space. The government in July, so middle of last year, said it would definitely be introducing a new duty on employers to prevent sexual harassment in the workplace. Again, though, when is that coming? As soon as parliamentary time allows. Maybe it will be 2022. The proposal there is to put a positive obligation on employers to prioritise the prevention of harassment in the workplace, sexual harassment in the workplace. There'll be a defence available to employers to show they've taken all reasonable steps, and that might be familiar to some people in other discrimination contexts. So if you can show you've taken all reasonable steps to prevent the harassment taking place. Also, although it's a positive duty to prevent harassment, claims can only be brought if an incident has actually taken place. You can't just bring a claim because you think people have sort of failed in that duty in the abstract. The final point on the sort of developments in employment law is that some of you might remember there was a proposal to introduce carers leave. That's still on the cards. You've guessed it, to be implemented when parliamentary time allows. Apparently, that will come in around the same time as those paying attention right back at the beginning when I was talking about flexible working. That's to come in at the same time that day one rights to request flexible working would come in. So we might see those in the next 12 months. I know that someone had asked a question earlier about whether we have been seeing a kind of general uptick in HR disputes and whether we think employees, particularly sensitive disputes, and I think the short answer is yes. I think I couldn't really give you a well thought out, considered response. My instinct is it's a kind of combination of quite a lot of sensitive issues being discussed more openly now, whether it's the sort of Black Lives Matter movement, the Me Too movements, or just an encouragement generally for people to what's sometimes described as bringing their whole self to work, not being afraid to talk about things that would have previously perhaps been brushed under the carpet or, hushed up. I think it's also, to an extent, working from home, as that question suggested, has had an impact. People are feeling perhaps a bit more isolated. Some people are feeling a bit more, a bit less secure in their jobs. And I think that feeds into people's reactions and sometimes, frankly, overreactions if they feel that they might be at risk. So just moving on, be it very briefly, really, to mention that the safeguarding really continues to be a priority for the Charity Commission. Remember, when we're talking about safeguarding in the context of the Commission, they mean protecting all people who come into contact with your charity, not just children and adults at risk. The Charity Commission's guidance, Safeguarding and Protecting People for Charities and Trustees, was updated in November. And the biggest change really was to add a section requiring charities to safeguard people when the charity is operating online. So that means having control over your website, over your social media accounts, YouTube accounts, whatever you have. So things like who can post, what content is and isn't appropriate for the charity to be posting, who can comment, who can edit, who moderates them. So have a look at that guidance online. It's pretty new, so we don't exactly know how it will be kind of interpreted and enforced. It is quite helpful and relatively self-explanatory. That final box there, continued focus on EDI. Certainly, you know, the change to the governance code, which actually was updated right at the end of 2020, but has really kind of filtered through in the last year, requiring all charities, small and large, to have an EDI plan in place, not just to put out statements saying they are committed to equality and diversity, but to actually say, what does that mean? What steps are you going to be taking to increase diversity and to address any inequality in your charity? At the Commission's public meeting, annual public meeting at the end of September last year, the Commission spoke in particular about trustee diversity and wanting to increase diversity on boards. So that leads me quite nicely to finish off my section by just plugging the webinar that I did at the end of last year on recruiting for board diversity. That's still up on the Russell Cooke website. It's on the Russell Cooke YouTube channel. So if you didn't catch that and you're interested in that, have a look at it. Thanks.
Okay, thanks, Carla. There's a couple of questions we'll pick up on the end, but actually just pick up on a point Carla made in response to a good question, pertinent question about trustees feeling a bit exposed with the context of cultural wars, employee activism, disputes of various sorts in relation to charities, and the perhaps slightly fractious context in which charity trustees may find themselves these days. I think looking at the bigger picture, it's also a really good time to focus on the fundamentals, starting with obviously knowing your mission, always being absolutely crystal clear on why your charity is doing what it's doing and being ready to articulate that. That was broadly the approach that RNLI took in relation to its criticism. It wasn't buffeted, it just kept explaining, this is what we are, this is what we do, and everyone was firmly on the same page. Second, working on the people issues, your team. As a board of trustees, you can't always control what's happening in the world around you, sometimes even what people do in your organization, but you can think about how effective a group of people you are to respond to issues, concerns, crises as in which they may arise. So really think about your trustee team and how you can make that as effective as possible in a context of working remotely in particular. And then thirdly is the importance as ever of good governance and making sure your governing documents and processes are up to speed. And we're finding increasingly there's activism of one kind or another, sometimes through membership of corporate charities to try to make changes in the organization. If somebody wants to use your governing document, if you're that sort of charity, to convene an EGM, to put forward a motion, what are the steps, processes and procedures, and are there sufficient safeguards? So maybe a time to reflect on some of that as well. I can see there's a series of questions which I'll pick up on as soon as I've finished the last point of the sort of formal bit of the presentation, which is just some other developments to look out for in 2022. So raft of some new legislation potentially coming through. Dormant assets, which is designed to give charities access to dormant assets, forgotten assets in relation to insurance and pension funds, which is potentially £800 million of funding that will become available for social, environmental purposes. There's procurement legislation coming through, and it's hoped this might make life a little bit easier for smaller charities, in particular part of more formal procurement procedures. There's some reforms that are likely to come through in connection with Companies House, relevant to charities with a corporate structure, and company transparency, requiring greater ID verification for directors, and also giving Companies House some greater power, for example, to scrutinise applications for new companies, whether that's a new charitable company or a subsidiary. And the Charity Governance Code, which was refreshed relatively recently, is going to be overhauled in 2023, and the consultation for that will happen during the course of this year. So that's the end of the formal part. Thanks for bearing with us.